Now I'll be telling you all about this act, which is known as the Punjab Shops and Commercial Establishments Act 1958. So this is an act to provide for the regulation of conditions of work and employment in shops and commercial establishments. So this line, it is clearly telling you that this act is applicable for shops and commercial establishments. Now, it extends to the whole of the Punjab state, and it shall come into force on such date as government may by notification in the official gazette appoint in this behalf, and it shall apply in the first instance of the areas specified in the schedule, but the government may by notification direct that it shall also apply to such other area or such date as may be specified in the notification. So this act says that it is applicable to the whole state of Punjab, and whenever the government by notification it will announce it in the official gazette, then it will come into force. As it is already being applied to specified areas in Punjab, but the government by notification can also add other areas on any date with the specified notification. Now I'll be telling you about few definitions that will come under this act. First is, what does closed means? So closed means not open for the service of any customer or for any other purpose whatsoever relating the business, which means that the shop will be closed on the day when it is not doing any business. Now what is a closed day? It is very simple. So this is the day on which the shop or the establishment it is closed. Now what is closing hours? So closing hours are the time at which the shop or the commercial establishment is closed. Now what is commercial establishment? You can clearly read that commercial establishment means any premises wherein any business, trade or profession is carried on for profit, and includes journalistic or printing establishment and premises in which business of banking, insurance, stocks and shares, brokerage and produce exchange is carried on, and which is used as hotel, restaurant, boarding or eating house, theatre, cinema or other place of public entertainment, or any other place which the government may declare by notification in the official gazette to be a commercial establishment for the purposes of this act. Means whatever establishments are mentioned here, they are included in this particular act, and the government may add more establishment in this after declaring it in the official gazette, and by that they will add other establishment in this particular act. Now what does a day means? Day means the period of 24 hours beginning at midnight. Very easy, 12 a.m. to 12 p.m. Now there is one case in which few employees they work at night. So what will be their working hours? So their working hours will start at the time when they will start working in the employment commences. So for them the day is not 12 a.m. to 12 p.m. but it is the time from where they will be start working in any establishment. Now what is an employee? So employee means a person wholly or principally employed in or in connection with an establishment, whether working or permanent, periodical, contract or piece rate wage or on commission basis, even though he receives no reward for his labor, but does not include a member of employee's family. Again, this definition is very important. So what an employee is? we all are aware whosoever is working in the company or getting the wages, compensation, or the salary the person is getting, then the person is called an employee. But here this is not the case. Even if there is a gardener who is working in the company, or a watchman, or you can call any person who is working for very few time in the company, or even if he is not getting paid for the work he is doing there, then also the person is called as an employee if he or she is working there for the company, but it cannot be a member of the employee family. So only the person who is working there, he will be called as the employee, and not his or her family member. Now, what is an employer? So an employer is a person having charge of, or owning, or having ultimate control over the affairs of an establishment, and include members of the family of an employer, a manager, agent, or other person acting in the general management or control of the establishment. So again, the meaning is quite very important to know. The employer is not just the person who is owning the affairs of an establishment, but it includes the members of the family of an employer as well. It can be the manager. Will be also called as the employer here. Suppose I am working in the company, and if I am the HR of the company, so I have certain responsibilities. So at that time I'll be acting as the employer of the employee if the person is working in my in charge. Now, what does an establishment means? So an establishment means a shop or commercial establishment. So the examples were already given above, like banking, we have a barber's shop, an IT company. These are private firms, so they will all fall under the act. What is a factory? Factory has the meaning assigned to it in the Factories Act 1948. So right now we will not be going to the Factories Act. Now, what is a family? Family is in relation to a spouse, children and stepchildren, and parents, sisters and brothers if residing with and wholly dependent upon him. So family will be immediate members. That can be your parents, your kids, your step kids. Then comes your brother and sister if they are dependent on you. What does a festival means? So festival means any festival which government may by notification declare to be a festival for the purpose of this act. Now, government means the Punjab government. Hours of work or working hours means the time during which the persons employed are at the disposal of the employer, exclusive of any interval for rest and meals. So hour of work will only include the working hour and not the meal or the rest hours. What does an inspector means? Inspector means an inspector appointed under this act. A leave means the time that we have borrowed from the employer for which we are getting paid, but we are not working during that time. So we are not working, but we will be getting paid by the employer for that particular time, hour or day. A manager in relation to an establishment where 5 or more persons are employed on an establishment whose owner does not ordinarily carry on the business personally, means a personnel declared as such by the employer in the prescribed manner. Very simple again. So if the owner of the company or the owner of the establishment is not able to get indulged in the business, then he or she might appoint a person on his behalf to take on the responsibilities. What does night means? Night means a period of at least 12 consecutive hours which shall include the interval between 8 p.m. and 6 a.m. Very simple again. So there is nothing to tell you about what does a night means in this particular law. Then we have what does opened means. Opened in relation to a shop or commercial establishment whose entrance is the only entrance to the residence means opened for the service of any customer or for any business connected with the establishment. Very simple meaning again. So if the establishment or the shop is ready to work or ready to carry out the roles at a particular time where the establishment is taking care of the customers or carrying out its work, so at that time it will be called as opened. What are opening hour? So opening hour means the hour at which an establishment opens. Suppose the company is getting open at 8 a.m., 9 a.m., 10 a.m. So that will be the opening hour of that particular establishment. Establishments are mentioned here. They are included in this particular act, and the government may add more establishment in this after declaring it in the official gazette, and by that they will add other establishment in this particular act. Now when we have what is spread over. Spread over means a period between the commencement and termination of work of an employee on any day. So this was the period during which an employee worked with the company. Now what does wages means? So wages meanings is already defined in the Wages Act 1936. Then what does a wage period means? So this is the period for which an employee is being paid for the work he or she do in the company. Now week means the midnight of Saturday. So when we stop working in the company at midnight and then it starts on the next Saturday. Now few companies they are 5 days working and few are 6 days working. So if the company is 6 days working, then it will be from 12 a.m. to 12 a.m. Saturday to Saturday, and if it is a 5 days working company, then it will work from Friday to Friday. Now what does a young person means? A young person is a person who has attained the age of 14 but has not attained the age of 18 years. These are the people from 14 to 18 years of age. Year, obviously the year starts from 1st April, so that is the year means. Now for the purpose of this act, an employment in the service of the employer of an establishment upon any work, whether within the establishment or outside it, which relates to or is connected with or in ancillary to the business carried on at the establishment, shall be deemed to be employment about the business of establishment. Then we have section 3. Now under this section 3, I'll be telling you that which establishments and persons are not getting covered under this act. So we have offices of central government, state government, Reserve Bank of India, Railway Administration, then any railway service, air service, water, transport service, tramway, postal telegraph or telephone service, any system of public conservancy or sanitation of any industry, business or undertaking which supplies power, light or water to the public. So these will not get covered under this act. Then we have railway, dining cars, these will not get covered. Offices of various lawyers or any person whose hour of employment are regulated by or under the Factories Act 1947. Establishments of stamp, bumpers and petition writers, they will also not get included under this act. Then we have the section 4. Now we have certain establishments which are under section 3 that are supposed to not get covered, but ultimately they are getting covered. So these establishments are clubs, hotels, boarding houses, stalls and refreshment rooms at the railway station. Or railway station is not railway facility, or railway stations are not getting covered under this, but the refreshment rooms there, they will be getting covered under the act. Then the shops of barbers and hairdressers, they will also be covered under this act. Then we'll have establishments dealing exclusively in meat, fish, confectionery, poultry, eggs, dairy produce, except for ghee, bread, sweets, chocolates, ice cream, cooked food, fresh fruits, flowers or vegetables. They will also get covered under this act. Then we have shops dealing exclusively in medicine or medical or surgical requisites or appliances, and establishments for the treatment or care of the sick, infirm, destitute or mentally unfit. They will be getting covered under the act. Then we have shops dealing in articles required for funerals, burials or cremations. Shops dealing exclusively in pans, betel leaves, berries or cigarettes of liquid refreshment sold in retail for consumption on the premises. Shops dealing exclusively in newspaper or periodicals, editing and dispatching sections of the newspaper, office and office of new agencies. They will also get covered under the act. Then we have places of public entertainment except cinema houses. They will be getting covered under this. Establishment for the retail sale of petrol and petroleum products used for the transport. Then we have shops in regimental institutes, garrison shops and troop canteens in cantonments. Then traineries, establishment engaged in retail trade carried on at an exhibition or show, if such retail trade is subsidiary or ancillary only to the main purpose of the exhibition or show. Then oil mills are not registered under this. Brick and lime kilns will not be included in this act. Commercial establishments engaged in the manufacturing of bronze, brass, utensils and such kind of processes which include melting in furnace. Then we have saltpeter refineries, establishments of commercial, college of shorthand or typewriting and other educational academies. They will not get included under this act. Then we have booking offices of the passenger and goods transport companies. They will also not get included. Establishments dealing exclusively in green and dry fodder and calf cutting and cycle stands, cycle repair shops, they will not get included in this act. Then we have other establishments which will not get covered under this, and they are establishments of cinema houses, establishments dealing in hides and skins, ice factories, establishments again engaged exclusively in repair of cycles or motor vehicles or service of motor vehicles, not being an establishment dealing in cycle or motor vehicles exclusively in spare parts thereof. An establishment dealing exclusively in providing on hire tents and other articles such as crockery, furniture, loudspeakers, gas lights and fans required for ceremonial purposes, and even establishments dealing exclusively in retail of bullions, murmura, sugar coated gram, riolis or other similar commodities. These will not get included under this act. Then we have that what is the power of the government to extend the provision of act. Now government at any point can add a class of establishments or remove a particular class of establishment under this act, and they will do it by providing a notification, and such kind of notification can be made by the government, and whenever it is made by the government it will be there and then be applicable. Then sixth point is what are the conditions of employment for young persons. Now for young persons, the work hours should not exceed 30 hours in any 1 week or 5 hours in any 1 day. By young person I mean people with 14 to 18 years of age, and these 30 hours in 1 week and 5 hours in 1 day excludes the intervals for rest and meals. And when we employ a young person in any establishment, then after 3 hours we should provide at least half hour for rest or meal. So we cannot give continuous more than 3 hours of work without such kind of 30 minutes break. And the government can anytime change the conditions or change the rules depending on the employment of young person about that particular business or establishment. If they feel that the conditions are not fit or the daily period of employment is not fit for that particular person according to the condition. And if any employer is not following these rules, then that employer is liable to get punished with, then that employer can be fined with amount between 50 rupees to 200 rupees. Now suppose that a young person has committed this offense under this act, then that person will be seen as a young person only till the time the offense is not proved, even if he attains the age of 18 plus years, but he has to be shown in the court till the time it is not resolved, and he will act as a young person only. Now 7th is the hours of employment. So under this act, whatever establishment are getting covered under this act, in that case their employees working hours should not exceed 48 hours in a week and 9 hours in one day. And in case due to workload or work pressure, if the employee is made to work more than the working hours defined under this act, then it should not exceed 50 hours in 1 quarter. Quarter means 3 months. And now is the remuneration. So if the employee is made to work beyond 48 hours in a week, then the person should be paid twice the remuneration which is calculated per hour. Now this thing will be explained. What are normal wages? Normal wages are the basic wages plus any allowances that includes cash for any other work which was included in the task list. Then what is the responsibility of an employer? So if any candidate or any employee is being employed in any day or in any week in his business, and if the working hours are getting exceeded, and then you are making the same person work in any other factory, so as an employer we cannot do that with one person, because that would increase his working hours ultimately. Now if by mistake, if the employer is getting such kind of person worked in his company, so he can show that he was not aware about it in that contravention, that he was not aware about this, that that particular employee was employed with another employer on that particular day. And the last is that as an employee or as a person, one cannot work for an establishment. So as a person or as an employee, one cannot work in any establishment that is making him or her work more than the exceeding hours, plus one person cannot work in 2 establishments simultaneously, and thus increasing the working hours ultimately. What are the intervals for rest and meals? So no employee except a chowkidar, watchman or guard shall be allowed to work an establishment for more than 5 hours before he has had an interval for rest of at least half an hour. So apart from a chowkidar, watchman and a guard, other employees cannot work in any establishment simultaneously for 5 hours without getting any half-hour leave or half-hour rest, provided that government by notification fix such intervals for rest in respect of any class of establishments for the whole of the state of any part thereof as it may consider necessary. So government can even fix such rest hours in respect to certain establishments if they feel they should. And any establishment should fix the work hours and meal hours or rest hours in such a way that total hours are not exceeding 10 hours in a day. Now, what is opening and closing hours? Government shall by notification fix the opening and closing hours of all classes of establishments, and different opening and closing hours will be fixed for different classes of establishment and for different areas. This is quite very simple to understand, so I'll not be elaborating this point. Provided that government may allow an establishment attached to a factory to observe such openings and closing as the government may direct. So when the government is made to fix the opening and closing hours for a list of establishments or a class of establishment, in that case they have to observe the opening and closing hours first. Now, what is a closed day? So this act says that Sunday should remain as a closed day for every establishment. Now, provided if the establishment is a factory, then the employer may substitute the closed day of such establishment so as to corresponds to substituted closed day of the factory in same manner and subject to same conditions as are laid down in this behalf in this particular act. So if Sunday is not the closed day, then the employer is made to make another day as a closed day in the factory or that particular establishment. Provided further that government may by notification fix any other day to be closed day in respect of any class of, again the same thing, that if Sunday is not a fixed day closed day, then the government has to, or the establishment has to make another day as the closed day in a week. Now next is that it is the responsibility of an employer to share the working hours of the company, the closed day of the company, and the meal hours in the company, and they have to share it with the prescribed authority within 15 days the company is registered in this particular act. So once the company is registered in this particular act, then it is their responsibility to share the working hours, meal hours, rest hours, and fixed close day with the authority of this act. Now the employer of any establishment, they can change the working hours, the period of interval once in a quarter of the year by giving intimation to the prescribed authority at least 15 days before that changes is to take place. This is also quite very simple to understand. Now, in what circumstances an employer can make his or her establishment opened on a closed day? If such day happens to coincide with a festival. If a closed day is near to any festival, then an employer can make the person work on a closed day and thus provide a leave for that particular festival. And then if the employer is making the employee work on a closed day, that is a Sunday or any other one day in a week, then the employer has to provide double the remuneration, which will be counted wages per hour. Now 11th point is that employees off day in a week. The next point is employees off day in a week. Again, these points are repeated. So an employee cannot work after the close hours, an employee cannot work on a closed day, and there should be one day as fixed closed in a week, and one should not work on that. So these points are already repetitive, which I have discussed above. Provided that a watchman, he is allowed to work on an off day under the section, and they are even need to work on closed days, Sundays, like this, because it is their duty. Now this is very important, what holidays. Now this is very important, how establishments are required to provide holidays to their employees. So if the employees is being made worked on a national holiday, for example Independence Day, Republic Day, and Mahatma Gandhi's birthday, then they have to give double the wages. for their work on that particular day. The government might add few more national holidays by notification, and same will be applicable to those days then.
Now, what is the registration of establishments and how can an establishment register itself in this particular act? So the employer is supposed to share the name of the establishment, address of the establishment, employer name, name of the manager, number of persons employed. So when the authority will receive the statement with all these information, then they will check the correctness and they will verify all these statements, and then they will be registering that particular establishment in the register of establishments. And after completing all these formalities, the registration of establishments, they will share a certificate with the employer if the inspector appointed in this particular act will ask the establishment to share the registration certificate, then on such demand the employer is responsible to share the registration certificate with that particular inspector. Now this registration certificate, it shall be renewed by 31st of March every year. They have to show that that particular establishment is actually working. This act is getting extended or there are some changes in the act, then all the establishments that will later come under the act, they have to register themselves. It is the responsibility of the employer to notify the prescribed authority about the changes they have made in the establishment, be it its name, the number of employees, or other changes. So it is the responsibility of the employer. And when the authority will receive such notice, then they need again to check the correctness of the changes made, and then they will add those changes and they will be changing the registration certificate if it is necessary. Now the next information, it is again something repetitive. So when this act is applicable on certain establishments, and when it's get extended, then the date on which this act comes into force, or when this act gets extended, then those establishments will automatically they will fall under this act. Now new establishments after amendments in the act which needs to get added into this act, so they will get added into this act from the date of which the establishment starts its work. Now it is the duty of the employer to notify the prescribed authority about the changes or any information contained his statement. Statement is again the information about the establishment, manager, directors. So they have to update the authority within 7 days after the changes has taken place. And the authority, they also need to check the correctness of the statements, and they need to verify all those things, and then the act they will provide a registration certificate with those amendments if necessary. Now the employer shall within 10 days of his closing the establishment. So if the establishment being closed, then the employer is responsible to notify the prescribed authority about closing of that establishment, and then again the process will be same, that the authority will verify things, check the correctness of things, and then they will make certain changes in the register of establishment, like they will be removing that particular establishment from its registers and will cancel the registration certificate. Now what about the leave policy under this act? Now if an employee has worked in the company not less than 20 days, that means the employee should work in the company for more than 20 days, then the person is entitled for earned leaves. So for every 20 days worked in the company, one earned leave will be given. So the young person shall be entitled to 1 day's earned leave for every 15 days of employment. So if the employee is 18 plus years, then for every 20 days worked in the company, they will get one paid leave. And if the employee is a young person, that is below 18 years, then that young person is entitled to one earned leave for every 15 days worked in the company. Now if the person is not utilizing the earned leaves, then these earned leaves will get encashed in the next financial year. So they have written it in a very different form. Like they have mentioned, if an employee is discharged or dismissed from or leaves service during the course of the year, he shall be entitled to leave with wages or wage in lieu of unavailed leave at the rates laid down in clause. So this is called as leave encashment. So earned leaves, they can be encashed if the person is not utilizing them. Now when we calculate leaves, so if an employee is taking more than half a day leave, then it will be calculated as 1 day leave. And if the person is working for less than half a day, then it will be ignored. So suppose a company works from 9 a.m. till 6:30 p.m. So if they are working from 9 to 2 p.m. say, and after that they have lunch. So if the person is taking a leave at suppose 1 p.m., then it should not be calculated as a complete half day, but as he has taken like 1 hour less than that half day, then it will be neglected. And if the person is taking like more than a half day, suppose the person is working till 4 p.m., then it will be considered as a full day leave. Now if the employee is not using the above mentioned leaves in a particular financial year, then these leaves shall be added to the leave kitty of the next financial year. Now if suppose the person has not utilized his leaves, and now these leaves are supposed to go into the next financial year, but it should not exceed 30 in case of 18 plus years employee, and if the person is young, then it should not exceed 40. I hope it is clear. Then the next is, now see, few companies, they might have a separate agreement. Suppose you are not utilizing leaves or taking leaves, and then suppose they do not want to encash it, or they do not want it to go to the next year, then they can utilize it in the extended holidays, weekly holidays, or other case maybe, and that will depend. See, ultimately this law has the goal of not increasing the work hours, the leaves be given to every employee properly. That is the motive of this law. But if some establishment, they are negotiating in such benefits to the employee, or if they are providing some like more than these things to the company, or they are providing more benefits to the employee as compared to what it is mentioned in this law, then obviously the more benefits the company is providing to the employee, that will be taken care about, and then this law has no problem with that. So if any establishment is not following what this law is saying, but they are providing some extra and over this law, then in that case they are not violating any of the law. Now suppose the employee has applied for a leave, then the employee is supposed to provide a valid reason to the employer, and if the employer is cancelling the leave request, then again the employer should have a valid reason in written given to that employee within 15 days of the application. Now suppose an employee applied for some leaves, and those leaves got cancelled from the manager, then that person can again apply for those leaves if he has not utilized those leaves. Now suppose the person has around 20 leaves in a year. Now he has applied 15 days of leave for a holiday, and suppose it is not getting approved by his manager. But even if it is not getting approved, later on he can utilize the same leave. So it's not that if the leave is not approved, then the person will not be given the leave benefit completely. He can utilize it on some other day then. Now comes the next point. So they have mentioned the unavailed leave of an employee shall not be taken into consideration in computing the period of any notice required to be given before discharge, removal, or dismissal. So they have written it in a very complex form, but I'll be telling you about it. So suppose not the employee is on his notice period. Okay, so in that case, obviously he needs to get discharged, removed, or he has to go through the dismissal problem. So even if during that time if he has certain leaves in his kitty, then the company is not liable to give him those paid leaves, or the company is not liable to take those leaves into consideration even if he has those unavailed leaves. Yeah, now again, very important point, and it is that the establishments are required to provide 7 days casual leaves and 7 days sick leaves in a year. So when you will be defining your leave policy for your establishment, then you should go ahead, you should read this act properly, and you should know that 7 sick leaves should be provided, 7 casual leaves should be provided, and that those earned leaves, which is for every 20 days worked in the company, a person will get 1 paid leave. Next is wages for close days and during leave period. Now it has again spoken about the earned leave here, that if the person is working for a minimum period of 15 days, then he should receive 1 off in a week. So now here the wages will be counted at the rate not less than the average daily wages earned by him for the days on which he worked during the week immediately preceding every such off day. So in this case, the wages will be calculated and it should not be less than the average daily wages. So this is how the leave will be calculated. It is saying that for the leave allowed to him under section 14. What is section 14? Section 14 is the leave policy. So if an employee is getting leave under the leave policy defined above, so again the employer is responsible to provide full earnings for those days on which he worked during the month immediately preceding his leave, exclusive of any overtime and bonus. So the paid leaves that we spoke about, earned leaves, casual leaves, sick leaves. So if a person is taking a leave for such time, then he will be completely paid for that. And it will not include any overtime bonus, so this will be entirely separate. So all the leaves, all the above defined leaves are paid, and if the person is getting bonus and overtime incentives, that is entirely different from this leave policy, and it has nothing to do with the leave policy. Now suppose an employee wants to apply for leave. So if a young person is applying for leaves more than 5 days, so on demand he can even ask the paid wages before leaving for that particular leave. Very simple. Suppose one young person is going on a holiday. So suppose the person is going on a holiday on 13th of April. Then before going on that holiday, he can ask for those 7 days or 10 days salary in advance even before going for the leave. So the employee has such authority. And if I talk about a person who is not a young person, then in that case, yeah, it is about 4 days. So it should be 4 plus days on demand. The employer is responsible to provide paid wages before going on the leave for such leave requests. Now wage period. Every company, every establishment is responsible to fix a wage period in which the employees will be paid for those wage periods. See, it can be monthly, weekly, daily, and no wage period shall exceed 1 month. So we need to provide 30 days salary. We cannot say that we will provide an employee a salary for 2 months, 3 months. So maximum it should be 30 days only. Rest one can provide wages basis weekly, hourly, daily basis. And right, this is also very important. The next is, suppose the employer is terminating his or her employee In that case, it is the responsibility of the employer. Then within 2 days after the employee is terminated, the employer is responsible to pay the wages earned by that particular employee, and the unavailed leaves, even that compensation has to be given to the employee within 2 days after the termination of that employee. Now, in this case, that particular employee has no right to claim any amount of money from the employer within 6 months of getting the discharge from that company or getting terminated from that company. But if the employee feels that he has not been paid fully after his termination, then within 6 months that employee can submit a complaint to the Chief Inspector of Shops and Commercial Establishments Act in Punjab. Then 17th point is deduction from wages. Now, what kind of deductions can take place in the wages? It entirely depends on the Payment of Wages Act 1936. Right now I will not be going into those details because that's a separate act, and I can define this act in my another video. Then the 18th point is realization of compensation. Now is the realization of compensation. Now, in case that the judicial magistrate feels that the employee has not been fully paid his due wages, then he shall direct the employer to pay wages along with compensation not exceeding 8 times the amount of wages withheld. So if the employer has not paid the terminated employee with the proper amount, then the employee can ask the employer to provide him his proper wages, and it can exceed more amount but not 8 times of that of the actual wages earned. Extra amount that the employer might have to pay is actually the penalty that is imposed under this act. So that is why I said that it can be 8 times than the actual wages earned. Then we have enforcement and inspection. So the government by notification can make a person or a group of persons to act as the inspector or an officer who has to look after the grievances under this. Now this inspecting officer has the right to visit the company, the premises of the office, and even he has the authority to check certain registers, records and notices in order to check the evidence for carrying out this act. This inspecting officer can only be a public servant, a government employee. Then we have next is record. The employer of every establishment has the responsibility to keep a note of the close day, working hours and the period of interval of employed persons, if any, and such other particulars as may be prescribed. So obviously every company needs to keep their records about all the employees, terms and conditions. So this is the responsibility of the employer. And the employer has to keep a record of the working hours, rest intervals, leave taken by the employees in the company, overtime they are doing. So everything should be recorded in the company. Maintain everyday attendance before the start of the day. So this is also very important, and everything has to be documented in registers. Even if everything is automated, still the registers have to be maintained. The employer is responsible for keeping a record of the photographs of employees who has completed 3 months in the company, continuous service, 3 months continuous service in the company. If the employee fails to provide a photograph to the employer, then the employer is responsible to keep a note of it with the signature of that particular employee that he has not provided his or her photograph within 15 days after the employee is confirmed in the company. He is responsible for maintaining such records as told you above, and if in case the act is adding more prescriptions or more additions or requirement in this act, then again the employer is responsible for maintaining all those records. If the employer is not able to maintain these records, then he can be fined not more than 50 rupees for every day if he is not maintaining the records. Now, if an employee intentionally or not intentionally is forging these records or removing any of the records, altering the records, then he can be fined between 25 rupees to 200 rupees or can be convicted to imprisonment for a term not exceeding 3 months. So for maximum 3 months that person can get even imprisonment. Next is inspection of registers and calling for information. Now in case any inspection gets occurred in any establishment, then it is the responsibility of the employer to keep the records and registers, and whenever the inspecting officer will ask for those records and registers, then he should be able to provide those information in case it is required. Again, if any inspection is getting occurred in the company, or if anyone is obstructing the inspecting authority to get the inspection done, or if someone is blocking a particular person from not giving the information, then again that person can be fined between 25 rupees to 200 rupees. Notice of removal. Now how can an employer remove any employee from the company? So no employee shall be removed from the services unless and until 1 month previous notice is given to him or pay in lieu thereof has been given to him. So an employer does not have the authority to fire anyone. The employer can only terminate someone or an employee by giving him 30 days of notice period, or he has to give the salary to that particular person. If he wants to remove it immediately, then 1 month salary has to be given. Now no employer has the right to remove any employee. An employer can remove an employee basis misconduct, and no employee shall be entitled to 1 month notice period unless and until he has not been in the service for 3 months, at least 3 months. Next is, in case an employee files a complaint against the employer that he has not been paid fully and he has been removed from the company without any reasonable cause, then the judicial magistrate shall for no reason to be recorded in writing award compensation to the employee equivalent to 2 months salary. Again, it's easy to understand. So if the employer has not paid his or her employee fully, that too after terminating him, then the employee has the right to raise a complaint in the local authority, and then the judicial magistrate might give a fine to the judicial magistrate would ask the employer to give 2 months salary to that particular employee for not paying him to the proper extent. But a complaint from the side of employee cannot be filed 6 months after the termination of that person. Next is notice by employee, that is the notice period by an employee. So if the employee has completed 3 months in the company, and if that employee is confirmed and appointed in that company, then he or she cannot leave the company without any prior notice of 7 days, or if he cannot serve that 7 days of notice period, then the employee is responsible to pay the company 7 days salary. Or in other case, if the employee is leaving the company without serving the notice period, then the employer can hold his salary for a period not exceeding 7 days. Now next is provisions as to trading elsewhere than in establishment. Next is provisions as to trading elsewhere than in establishment. So there are certain rules where a particular class of establishments can get opened in a particular premises. So if any establishment or any company is not following those rules or getting their establishment opened in some precise in some premises where it is not supposed to do, or it is not supposed to carry out such kind of business in that area, then that employer can be kept open in contravention of the act. Now what will be the penalties if such kind of thing is happening? Any establishment or any employee is making contravention of the act in any form, even if it is defined in the act or not defined, but if every contravention is there related to this act by the employee or employer, then they are liable to a conviction, to a fine which is not exceeding 100 rupees for the first time. So it should be less than 100 rupees, and if they are repeating it after this, then it should not exceed 300 rupees for every offense they are doing every day, provided that that offense should be from the same year, and the fine should not be less than 100 rupees in any case. Is the protection of officers and their agents from personal liability. No suit, prosecution, or any other legal proceeding, or any lawyer cannot stand against the inspection officer. So no lawyer, no public servant of central government, state cannot stand against the inspection officer. So in this way, the inspecting officer will get protected under this act. Now next is power to grant exemptions. Obviously the government or any officer empowered, the government or the officer appointed has the authority to make changes in the official gazette and to grant exemptions about the sections mentioned in this act to any employee or employer in the industry. So the power to grant exemptions is only to the government or the officer appointed. Only he can exempt a particular employee or establishment under this act, that too by notifying it in the official gazette. Next is prohibition of employment of children. No child who has not completed the age of 14 years shall be employed in any establishment. Very easy. Next is condition of employment of women. So no employer should engage a woman employee intentionally or unintentionally if the woman had a miscarriage, and for the following 6 weeks she cannot work anywhere, and an employer cannot make her work for 6 weeks after her miscarriage. Next is the maternity benefit. So this is for every woman who is employed in an establishment, and the woman should be employed in the company for at least 6 months, and then she can get this maternity benefit. And if she is applicable for this benefit, then she will get, and she will be paid during the 6 weeks immediately preceding, including the day of her delivery, and for each day of 6 weeks following her delivery. So before her delivery 6 weeks paid leave, after her delivery again 6 weeks paid leave will be there. Though this maternity benefit act has been changed now, so instead of following the Punjab Shops and Establishment Act, one can follow the Maternity Benefit Act in India. Next is bar of legal practitioners in certain proceedings. Under this, if there is any contravention in this law, or if there is any contravention by any employer or employee under this act, then during the proceedings in the court, no legal authority has the right to to appear, plead, or act for the employer or the employee in any proceedings before the court. Next is savings of certain rights and privileges. Whatever benefits we have discussed in this law, if some other law in India is giving more privileges or rights to any employee or employer, then that act will come into, then that act will be applicable and not this one. Next is cognizance of offenses. In case there is any cognizance or any offense which is punishable under this act, then it has to be in a written form on behalf by the government. So this is the responsibility of the court, that they have to take care of such hirings in writing on behalf of the government. Then next is the power to make rules. Government can make rules for the purpose of giving effect to the provisions of this act. Government may make rules for the purpose of giving effect to the provisions of this act. This is quite simple. So this will tell what kind of powers this act has. So it has the power to change the manner and form in which the registers and notice shall be kept. A. The manner and form in which the registers and notice shall be kept. B. The officers who may be empowered to inspect registers and call for information as required by this act. C. The agency by which and the manner in which the prosecution shall be instituted. D. The form of submitting a statement, the particulars under subsection 1 of section 13, the manner in which registration of establishment is to be made, and the form of registration certificate under subsection 2, and the form of notifying a change under subsection 4 of section 13. E is the authority to and the manner in which any notice required by this act shall be given. F is the conditions subject to which any exemption under this act may be granted. G is the manner in which the employer of an establishment shall keep exhibited in the premises a closed day, closing and opening hours, and such other particulars as may be prescribed, and to safeguard health, safety, and welfare of the employees while on duty. And all rules made under this section shall, as soon as possible after they are made, be laid off before the state legislature. 35th is re-appeal. So the Punjab Trade Employees Act 1940 is hereby re-appealed, provided that A. Every appointment, order, rule, bylaw, regulation, notification, or notice made, issued, or given under the provisions of the Act so repealed shall, insofar as it is not consistent with the provisions of this Act, be deemed to have been made, issued, or given under the provisions of this Act, unless and until suppressed by any other appointment, order, rule, bylaw, regulation, notification, or notice made, issued, or given under this Act. B. Any proceeding relating to the trial of an offence punishable under the provisions of the Act so repealed shall be continued and completed as if the said Act has not been repealed but has continued in operation, and any penalty imposed in such proceedings shall be recovered under this Act as repealed. So this was all about this Act. The Act was quite very long to explain, though I explained few topics precisely, but not every point was covered properly here. In case you have any queries, you can comment in the section below. Rest, all the very best to everyone. Take care. Bye.